Hi, everyone. I'm Lisa Palumbo, the Director of the Immigrants and Workers' Rights Practice Group at Legal Aid Chicago. We'll get started in just a minute. We'll be right with you. Hi, everyone. We're going to get started now. Good afternoon. My name, again, is Lisa Palumbo. I'm the Director of the Immigrants and Workers' Rights Practice Group at Legal Aid Chicago. Welcome to Legal Aid Chicago's second session of our series, Legal Aid Matters. Today's session is entitled El Asilo es un Derecho Humano. Asylum is a human right. Asylum through the new arrivals lens. It's an in-depth look at how our immigration team has been helping those seeking asylum over the last year. It's been a challenging and rewarding time for our staff, and we'd like to share some of this information with you. But before we get started, a couple of administrative details. First, please sign in with the link found in the chat to obtain CLE credit and to give a course evaluation. We really value your feedback. Second, if you have any questions or comments during the presentation, please use the Q&A function at the bottom of your screen. We'll be happy to address as many questions as time permits directly following the session. Third, we will be recording this session and all future sessions so we can make them available to those who can't attend. The recordings will be made available at the end of the series, and today's slides will be emailed after the session. And now to our session.
Thank you, Lisa. Good afternoon, everyone, and thank you so much for being here today and engaging in this important topic of asylum through the new arrivals lens. My name is Maggie O'Connor. I'm a staff attorney at Legal Aid Chicago, and I use she, her pronouns. After about 4.5 years in private practice, I joined Legal Aid Chicago in immigration and human trafficking projects about 6 months ago. I primarily work on securing immigration relief for survivors of crimes. My colleagues will introduce themselves as we move through the presentation. But first, I'll introduce who we are as an organization. Legal Aid Chicago is an organization of approximately 230 staff, half of which are attorneys. We are part of the Immigrants and Workers' Rights Practice Group at Legal Aid Chicago, which houses 4 projects. We in immigration focus on providing our clients with various forms of immigration relief, including but not limited to asylum, naturalization, work authorizations, U visas, adjustment of status, special immigrant juvenile status or SIJS, and deportation defense. Today, we'll talk about new arrivals and we'll apply the facts of their cases to the legal framework to demonstrate the challenges and benefits of the asylum process. Please look throughout and after to the materials that were emailed to you prior to today's presentation. A link to the materials is also being posted in the chat. So before we jump into our experience with working with new arrivals, I wanted to provide some context as to who we're talking about when we refer to new arrivals. New arrivals have been in our local news since Texas started sending buses of immigrants to DC and New York, and then to Chicago last summer. We want to zoom in a bit on exactly who is coming to Chicago and how. Since the arrival of the first bus about 8 months ago, a total of over 5,000 new arrivals have come to Chicago, the majority of which arrived in those first few months, but we've been seeing buses still arriving, tapering off a little bit, mostly in November and December, and we are still seeing people making their way to Chicago individually. Most of the new arrivals are coming from Venezuela, with some coming from Peru, Colombia, Nicaragua, Ecuador, Cuba, and our office even has one client from Iran. Chicago has also received some individuals from countries in Africa, Europe, and the Middle East. So what is bringing these migrants to Chicago, to the United States in such large numbers? There are a few main factors that we're seeing driving this wave of migration. The first is extreme economic crises. We're not just talking about people who have low incomes or joblessness. Our clients describe an inability to provide their children with even one meal a day, even when they're working full-time, or the inability to buy basic over-the-counter medicine when it's available in stores. So extreme economic crises. Another factor is political oppression. Venezuelans are forced to support President Maduro or face a variety of life-threatening consequences, including being cut off from government services. And in both Venezuela and Nicaragua, there are extreme government crackdowns on political opponents and free speech. Finally, we're seeing violence as a major driver of this wave of migration. Our clients face forced recruitment by mega gangs, so gangs that span large swaths of the country or even the entire country, and paramilitaries and/or forced extortion, followed by extreme violence. Among many other kinds of violence, the violence for extortion comes for an inability or refusal to pay these mega gangs. This makes people feel that they have no choice but to flee.
Hi, my name is Romina Nemaei. I use they, them pronouns, and I am a staff attorney in the Immigration Project. I mainly work on asylum, temporary protected status, U visas, and naturalization cases. We'd like you to follow our clients throughout the asylum process, and in the process, we hope that you'll learn the legal requirements to be able to apply the elements of asylum and assess the strength of their cases. We've changed their names for their safety, but we'd like to introduce you to Luisa and Carmen, who are both from Venezuela, but had to flee for very different reasons. Luisa suffered political pressure and threats at her government job, while Carmen survived extreme domestic violence, which is similar to Ava's case from Iran. As a disclaimer, when we get into the facts of our two clients' cases, we will describe some very difficult facts, including rape and attempted murder. Our clients arrive in the US by various means, but mainly on foot. Ava escaped from Iran by going to Turkey, only to be found by her persecutors. She then fled Turkey to Venezuela, one of two countries in Central and South America where it is not necessary for Iranians to have a visa to visit. From there, Ava and Carmen and Luisa's journeys were similar. They made their way on foot and bus and sometimes motorbike from Venezuela to Eagle Pass, Texas. This trek of around 2,500 miles took our clients and their families through Venezuela, Colombia, Panama, Costa Rica, Nicaragua, Honduras, Guatemala, and finally, Mexico. You can see it to the right of the slide, the Darien Gap, one of the world's most dangerous jungles. This area is extremely difficult to pass and ripe with instances of rape, extortion, serious bodily injury, and harm. Please look to Article 6 from the LA Times that covers the dangerous trek through the Darien Gap through the eyes of an asylum seeker. Now we'd like to talk about some of the government actors and processes that new arrivals encounter when coming to the United States. The different agencies and the ad hoc nature of processing and policy implementation leads to a great deal of confusion for these new arrivals. There are three separate agencies that are nestled within the Department of Homeland Security. United States Citizenship and Immigration Services, or USCIS for short, which many new arrivals interact with when they file applications for asylum and work authorization. All new arrivals have contact with U.S. Customs and Border Protection, or CBP, which processes new arrivals at the southern border. Finally, we have U.S. Immigrations and Customs Enforcement, or ICE. All new arrivals interact with ICE throughout their time in the United States, within the country, with periodic ICE check-ins. Under the Department of Justice is the EOIR, or Immigration Court. This adjudicates deportation and removal proceedings because immigration judges adjudicate the applications for relief, such as asylum, and can order individuals deported. The prosecutors in these proceedings are part of ICE, or Immigrations and Customs Enforcement.
By the time the new arrivals reach us, they have encountered the alphabet soup that is immigration agencies that Romina just described, and they face a set of deadlines and reporting obligations. And before I jump into each agency, note that for many of our clients, the process is not linear. This graphic is intended to demonstrate that some of these obligations are ongoing, and the lack of communication between agencies can be a minefield for our clients. So I'll explain them all in the order in which it is common for clients to encounter them, but many will be dealing with all of these agencies at once. Beginning with Customs and Border Protection, or CBP, this is the first stop for new arrivals. Many new arrivals express their fear to return to CBP agents. And Alix will talk more in a moment about this first encounter. If they're granted parole, which is a temporary authorization to enter the United States, as is the case for many of our new arrivals, their next main immigration agency, that is the U.S. Immigration and Customs Enforcement, or ICE. They'll be given a check-in appointment and have ongoing reporting obligations with ICE. If they have a fear of return and are not in immigration court, they can apply affirmatively for asylum with USCIS, and they will be interviewed at the asylum office. The asylum office has the authority to grant those asylum applications or to refer the case to immigration court, where they'll have a chance to present additional evidence in support of their asylum cases. Immigration court is where new arrivals will receive a final adjudication on their claim or other applications if they've been eligible for others. And this decision on their asylum case could be either an approval or a referral to in immigration court can be a denial, which would be accompanied by a removal order. So if this graphic looks confusing, it's because it is. It's confusing to clients, it's confusing to attorneys, having to figure out who needs to know what information and where to send applications.
Hi everyone, good afternoon. My name is Alix Strunk. I am a supervisory attorney here at Legal Aid Chicago. I use she, her pronouns. I've worked as an immigration attorney in Chicago for over 12 years in both private and nonprofit sectors. And I'm currently supervising the Immigration Projects team work with new arrivals. And so I'm happy to be here with you all today. So let's go back to what Maggie just described as that first moment of contact with government agencies at the border. The vast majority of new arrivals are coming to checkpoints. So those are authorized border crossings such as bridges and checkpoints, and they're presenting themselves to CBP, Customs and Border Protection, who then processes these individuals by taking their fingerprints and pictures and checking for prior immigration history. Now, normally individuals who enter the US or who come to the US without a visa are not permitted to enter the US. So they are either turned around or processed for an expedited removal, which is a deportation that happens very rapidly and without an immigration judge. Expedited removal isn't supposed to apply to those who have a fear to return to their home country, but that's not always the case. One reason why we're seeing such a large number of new arrivals from these particular countries is exactly because of the country that they're coming from. So the US doesn't currently have diplomatic relationships with Venezuela, Cuba, and Nicaragua, so we can't deport people to those countries. And Haiti doesn't have a government that's able to accept deportations. So then, after people are physically present in the US, many are granted a parole or an authorized release by Customs and Border Protection. Many people are receiving about a 2-month parole And it's a quasi status that, as I said, enables people to enter the country when they otherwise wouldn't be able to, but it doesn't come with a work authorization, and it's certainly not permanent. More, it's a reflection of the fact that the border agencies don't have enough time and capacity to deal with these numbers that are coming across, and they need more time to process all of these new arrivals. So some are detained initially. We'll go back to the last slide for a minute. Thank you. So some are detained and then released with alternatives to detention, such as an ankle bracelet or an ICE issued phone for virtual check-ins. Some are released on their own recognizance. And then many leave Texas for other states, either via the state-sponsored buses or on their own.
So who is actually eligible for asylum? I want to talk about how many of the new arrivals came to the US to seek asylum and the difference between being eligible to apply versus being likely to have your case granted, who actually will qualify for asylum. So as a preliminary matter, everyone who has a fear of return to their country of origin and is in the United States has a right to apply for asylum. This is part of longstanding international obligations that the US has been party to for a long time. So everyone has the right to apply. But the main idea is that anyone who applies doesn't necessarily automatically qualify. Only a small number actually will win asylum. So of all the filed cases that meet all the legal qualifications, only a tiny percentage are approved compared to the number of applications filed. And we'll talk about this later, but approval rates do vary significantly by adjudicator and location. If you look at Article 4 in your materials, you'll get a more detailed overview of asylum. The legal requirements that someone must, as a threshold matter, be able to meet they come from the Immigration and Nationality Act's definition of a refugee, which asylum seekers must satisfy in addition to other requirements. The definition of a refugee is much more than just subjective fear. To merit a grant of asylum, applicants must show that they cannot return to their country of citizenship because the government is either unwilling or unable to protect them from persecution. Applicants must then show that they are or will be persecuted on account of one of the 5 protected grounds listed here: race, religion, nationality, membership in a particular social group, or political opinion. And as I mentioned before, these applicants must be present in the United States. That's what makes them distinct from a refugee. Notably absent from this list of protected grounds is general violence and economic crises, which, as we mentioned earlier, are 2 of the major drivers of this migration. Although that may be a reason for people to flee, this general violence or economic hardship alone is not enough to qualify for asylum. So what is this well-founded fear? If you haven't suffered past persecution on account of these protected grounds, you must show at least a 10% probability of future persecution. The past or future persecutor must be a government actor or an individual the government is unable or unwilling to control. Our clients can show things like attempts to report to the police or evidence that the individual actor has ties to the government that make that actor immune to their complaints. Country conditions experts and documents can help show these things. But it's not enough to say that a private actor in a failing state like Venezuela can act with impunity. Applicants must prove why the persecution occurred. The harm suffered must be on account of a specific protected ground, which is the nexus that's referred to there. For new arrivals, we are seeing several common protected grounds that we'll focus on today: political and imputed political opinion, and particular social groups, which can encompass certain domestic violence survivors, gang resistance, or anti-corruption actions, just to name a few.
So even when somebody meets all of the initial elements that Maggie just outlined, there are other hurdles to winning an asylum case. One big hurdle is the deadline to file for asylum within the first year of arriving in the US. And this deadline applies even if somebody doesn't know of the deadline or hasn't been advised of the deadline by the government or an attorney. And it's true even if someone is dealing with intense trauma issues from their journey or from their persecution, or having trouble because of language issues. Luckily, there are some exceptions to this 1-year deadline. For example, there can be statutory exemptions. Certain Afghan applicants are exempted from this 1-year deadline. There are also, if you can prove exceptional or changed circumstances prevented you from filing timely, that can be a way to get around the 1-year deadline. But in order to make and to win that argument of exceptional circumstances, you really need the help of an attorney, and attorneys are not provided by the government for these asylum applications. Now, asylum law is very complicated and it comes from many sources, which is just one of the factors that makes it so difficult for applicants, for pro se applicants, to apply and to win their cases. Our most important body of law comes from the Immigration and Nationality Act, which is in Title 8 of the US Code, and its accompanying regulations. We also have case law, both in this area from the 7th Circuit, but also the Administrative Board of Immigration Appeals. And then, of course, there are lots of executive actions that also influence immigration law.
And there are even more hurdles for asylum applicants. These include statutory bars and inter-country agreements. So those who have engaged in persecution or provided material support to a terrorist group, they are barred from asylum. This makes intuitive sense, but the rule has some extremely harsh consequences for deserving applicants, like in the case of forced child soldiers or those who are threatened at gunpoint to provide ransom payments or even food to mega gangs or paramilitaries, such as the FARC in Colombia. Generally, these bars apply even when an individual is forced to act under duress. There can be statutory exceptions. For example, the material support bar has been waived in part for Afghan applicants. But you can also be barred from asylum if you have firmly resettled with lawful status in another country, or you are able to internally relocate in your home country within reason, or if you have committed particularly serious crimes. Inter-country agreements and presidential decrees can also limit a person's ability to apply for asylum. There is the Safe Third Country Agreement with Canada, which provides that a person must apply for asylum in the first safe country that they land in, typically either Canada or the United States. Canada has made the news recently because some US arrivals have decided to issue United States asylum applications and apply for asylum in Canada. But this is restricted under the agreement, which was updated very, very recently by President Biden and Prime Minister Trudeau. Title 42 public health order allowed the government to restrict who was entering the United States because of COVID. This has been rescinded and stayed multiple times and now is set to expire on May 11th, 2023. Finally, proposed transit bans. These transit bans bar asylum seekers from entering the United States at the southern border if they had traveled to a third country prior to entering the United States, and they did not apply for asylum in that country. President Trump issued one such ban, which was later rescinded, and President Biden has proposed a ban called the Circumvention of Lawful Pathways. Bans like these, they restrict asylum seekers like our clients from being able to seek asylum because of the many countries that they pass through in order to reach the United States. Please see Article 5 in your materials for more information. Even while an applicant waits for their application to be processed, there are certain benefits of applying for asylum while the application is pending. One of those benefits is that is a work authorization which comes after a number of months. For those who file with U.S. Citizenship and Immigration Services, they can apply for authorization after 150 days. And the application is supposed to be adjudicated within 30 days, so a total of 180 days. For those applicants who are in immigration court, the work authorization clock can stop and restart. depending on applicant cause delays, like seeking a continuance or finding an attorney. Once approved, an applicant will have legal status as an asylee. After holding the status of an asylee for 1 year, they have a pathway to apply for permanent residency or a green card. And then after 5 years of holding a green card, they are able to apply for citizenship. Asylees may also petition for family members included on their asylum application to come to the United States and join them inside the country.
So now we'd like to really introduce you to our clients and dive into the details of their story. So Luisa is from Venezuela, and she came to the US with her husband and 2 children on foot. They had to flee because of political pressures and fear from both of their jobs. Luisa worked for a state-owned oil and gas company, and she felt forced to condone and participate in corruption at the job, which she was opposed to. She discussed some of these problems with her supervisors, but her supervisors made it clear that if she reported the corruption, she would be the first one to face consequences. Luisa was too scared to take any further action and ultimately quit her job without incident. So, how strong is Luisa's asylum case? Please answer the poll that will appear on your screen. Okay, I don't see a poll. And oh, here's Luisa's poll. Okay, if there's some of you who are still thinking it over, that's fine. We'll hop on to the next slide and discuss some factors of her case. Okay, so I see it was a split almost 50-50 with a little bit more voting for not a strong case. Okay, let's find out. So as with many cases, there are strengths and weaknesses to Luisa's case. So first, let's discuss the favorable factors. First, her would-be persecutor and their ability to cause harm is clear. There are direct ties to the government because of her job. Opposing corruption can be a political opinion, or, for example, taking anti-corruption actions can be an imputed political opinion, which is also a protected ground. We do have some questions about her claim where we might need more information. So, for example, the threats that she suffered, how immediate were the threats? Threats can be sufficient to constitute past persecution, but they do need to be imminent and severe. Here, it doesn't seem that Luisa's threats were sufficient, from what we know, to constitute past persecution. Luisa's proposed protected ground is her political opinion. That is also a bit of an issue here because the facts that we have don't show that Luisa took enough anti-corruption actions to cause her would-be persecutors to seek to harm her in the future. So can Luisa apply? Absolutely. She is scared to go home, and she suffered problems that make her objectively scared to return. But this is really an example of how asylum is very complex, and factual information can really change and make big differences. So our position is on these facts without more, Luisa's case is not a very strong case.
So while Alix explained Luisa's claim, which is based on a political opinion, I'm going to cover another very common protected ground, which is the particular social groups. It's one we see a lot in general, but also with our new arrivals. Members of a particular social group must share a common immutable characteristic. And by immutable, we mean one that they cannot or should not be required to change. They must be socially distinct within their community of origin, and this PSG must be defined with particularity. Some examples of successful PSGs are married Guatemalan women, gay Jamaicans, former taxi drivers who opposed the FARC, former girlfriends of members of the MS-13, which is a notorious mega gang in El Salvador. So these are all examples of how you might define a PSG with the right particularity. This is a very dynamic area of the law. In recent years, we've seen AG, Attorney General intervention in what qualifies as a sufficiently particular social group. And you'll see in your materials, one of the very first item listed, some of the background on matter of AB and matter of ARCG, which are cases that discuss this particular social group change in recent years. Keep in mind that the complexity of this protected ground biases adjudicators heavily in favor of applicants who have attorneys, just because of how heavily discretionary and how ever-changing this area is. And if you are seeking CLE credit, you'll see on your screen the CLE code AG3322. So we encourage you to write that down and keep that in your records for your credit after this. So now I'm going to jump into a client and we can engage with this PSG protected ground. So I'm going to tell you about Carmen. She is a young woman from Venezuela who has been dating a man named Beto for many years, and they had several children together. Beto is a member of the Tupamaros, a gang with ties to violent paramilitaries loyal to President Maduro in Venezuela. Beto regularly beat and raped Carmen, forced her to work, and once threw gasoline on her and her children. Carmen and her children finally escaped to Colombia, but Beto found her and the police wouldn't protect her because it was, quote, a domestic matter. This cycle repeated many times. Carmen tried to escape with her children and Beto would find her. So with those facts in mind, please participate in the poll that should be appearing on your screen and answer whether you think Carmen has a strong case. Okay, so you can see the results of this poll. The majority of you, about 90%, answered that yes, she has a strong case, and we agree. Carmen belongs to a particular social group. If we could go to the next slide. She belongs to the particular social group of women who are unable to leave a relationship. Even though she wasn't married, she couldn't leave her relationship to protect herself. She had demonstrated that she tried. When she fled to another country, Beto came and found her. The persecution she faced was on account of her membership in that group. For example, Beto didn't treat all women the way he treated Carmen. The government actors necessary to show that this was the perpetrator of the persecution was someone who was part of the government. Beto's ties to the Tupamaro and the Tupamaro's power and influence in the government make him a person that the government cannot or will not control. So, and part of this analysis as well is the fact that he has these connections and ties to government actors. The police demonstrated that they could not and would not protect Carmen when she tried to report to them, and they said it was just a domestic matter. The fact that Carmen tried to flee, but Beto kept finding her, largely through his Tupamaro ties through Venezuela, shows that she could not internally relocate. So Carmen likely has a strong asylum case.
So now I'd like to talk to you about Ava. Ava's story begins with her abusive religious family who restricted her ability to go to school and married her to a very abusive man. Then she was detained and raped by the Iranian Revolutionary Guard as punishment for wearing her hijab or head covering incorrectly. Finally standing up for herself, Ava divorced her abusive husband and remarried for love. However, in response, her own family attempted to kill her to regain their honor. Ava sought refuge in Turkey, where she obtained a tourist resident card that had no legal right to work attached to it. She was found there by her family and narrowly escaped an attempted abduction to bring her back to Iran and have acid thrown on her and be killed. From Turkey, she then fled with her son to Venezuela because that is one of 2 countries in the Americas that does not require a visa for Iranians, while her second husband remains in Iran. Please respond to the poll on your screen that will show up momentarily as to whether you believe, based on these facts, that Ava has a strong asylum case or not. So based on the results of the poll, roughly 77% of people believe that Ava has a strong case based on these facts. If we could go to the next slide. So let's consider the following factors. Particular social group and nexus. These family statements show that they were trying to harm and control or punish her on account of her status as a non-religious Iranian woman who resisted a forced marriage. Her persecution was linked to gender, rape as torture, honor killing as a way to control or punish women. To consider government inability or inaction, the Revolutionary Guard of Iran is an arm of the Iranian government, and their assault on her counts as government persecution. While her family members are private actors, Ava can demonstrate that the government has an inability or unwillingness to act or intervene because country condition evidence shows that the Iranian government does not protect women from honor killings. And finally, Ava was not firmly resettled in Turkey because she had no lawful permanent status there. A tourist visa doesn't count. She also wasn't safe from her persecutors there. Ava likely has a strong asylum case in the eyes of our office.
And thank you all for participating in those polls. I think you can see from the results that we had, none of which were unanimous, that sometimes identifying the strong case can be challenging. And again, just the difficulty and highly discretionary nature of successfully applying for asylum. Not only can the legal analyses of an asylum claim be challenging, but also clients face a number of administrative and logistical challenges. To name a few, we see inconsistencies in case processing. New arrivals receive different parole or admission periods and different documents relating to immigration court. They will have ICE check-ins years out or in cities where they've never resided. They may also have to report changes of address to up to 3 different agencies. And again, when your case is pending for such a long time, this obligation is ongoing for years. It can be a minefield for clients and even their lawyers to keep track of all the different agencies, especially when cases take several years to process, and the stakes of missing a single hearing or check-in are so high. Another challenge is the highly discretionary nature of asylum adjudications. As you can see from the statistics we've gathered here, just as a few examples, these outcomes are highly inconsistent. Within one city, just Chicago, we see grant rates, depending on the judge, from between 9% and up to 83%. And then outside of Chicago, comparing Chicago to Atlanta, the high end of asylum grants is just 10%. So within Chicago, you might get a judge who only has a grant rate of 9%. But if you leave the city, that's on, sort of the high end. So we just see a lot of differences in how different adjudicators are looking at and deciding these cases. Another aspect, like we've been discussing thus far, is the legal challenges. So as we see with these new arrivals, many of whom come here because of gang violence and economic downturn, that's unfortunately not sufficient to win asylum. But generally speaking, there are some cases where this persecution, there's persecution based on one of the 5 protected grounds. It just requires a lot of nuanced legal analysis, and it can be challenging for someone to determine whether they're eligible or whether they will have their asylum case granted. And a lack of clarity for persecution by private actors, as in the example of Beto and Carmen's case. Technically, he's a private actor, but we were able to suss out these details of how he's connected to the government and why they were not able or willing to hold him accountable. That's a pretty clear example. Some cases is a lot more nuanced, and it hasn't gotten any easier to determine whether these cases will be successful because of this recent changes in the analysis of the private actor. And we've been seeing a lot more cases that initially started the asylum office getting referred to immigration court simply because of the complexity and recent changes in this analysis of a private actor perpetrating this persecution. So you can see the first article in your materials again to show more about how this PSG or particular social group analysis has changed and the difficulty of it. An additional challenge we see with our clients is interpretation and translation issues. If the client speaks any language other than Spanish or English, securing interpreters for an official immigration proceeding can present serious delays or even due process concerns. We see these interpretation issues all the time. Ava, for example, will have to bring her own interpreter to the asylum office as a Farsi speaker. Someone who qualifies as an interpreter has to not only be fluent in Farsi and English, but they also have to feel comfortable interpreting in such a high stakes environment. If an applicant does not have an interpreter, this may delay their case. So we talked about how some of these cases can take a really long time before they are scheduled for an interview in front of the asylum office. And imagine waiting that much time only to have your case kicked for interpretation issues, inability to find a proper interpreter. I've even seen in immigration court a group of children who spoke Punjabi as their first language. The court relied on one of the children who spoke some English to interpret for all of the other children there. So it just shows the struggle to get everything lined up for interpreters as well. And then again, these delays. So the delays and confusing paperwork can result in claims becoming weaker over time. For example, if the applicant becomes further removed from the persecutors and the harm, or sometimes we see country conditions change, that can result in changes in the strength of someone's application when initially it might have been very strong if it had been heard right away. The length and duration of these proceedings can also cause clients to miss court hearings if they fail to update their address or to do so properly. They might miss a notification of a hearing, and missing a hearing, as we mentioned before, is really high stakes. Judges have the authority to enter orders of removal or deportation in absentia if someone fails to appear at their hearing. So you can look at your materials, articles 2 and 3 there for more information on these challenges. So let's walk through how our office is helping Carmen. First, our office will help her file her asylum application, which includes her family. Then 150 days after it's been filed, she'll be eligible to apply for a work permit. Then after a wait, one of the 2 agencies could adjudicate Carmen's application. Carmen doesn't have a court date yet, but she does have a charging document used to initiate removal proceedings. So we aren't sure who will ultimately decide her application, whether it will be the asylum office or immigration court. She'll file with U.S. Citizenship and Immigration Services, or USCIS, which may send her application to the asylum office for a non-adversarial interview or send it to the immigration court to start her removal process. If Carmen's interview is with the asylum office and the officer doesn't grant her application will be sent to immigration court for a second chance on her asylum application. In immigration court, Carmen will face adversarial hearings with an ICE trial attorney or prosecutor. And our goal throughout this is to help Carmen keep her family together. So we're going to help her consolidate her case with her children and consolidate with her children and her husband, Jose. And finally, the family will go through a series of master calendar hearings as the case is pending, possibly for years. These are basically just a status hearing. And before the individual hearing, the judge will have all these status hearings, and then they'll set what's called a merits hearing, and they can decide Carmen's case at that hearing. So there'll be a series of check-ins along the way, and again, failure to appear at any of those could have serious consequences for Carmen's case, but we will be helping her remember and appear for those. Our goal is to help Carmen win asylum and keep her family together and safe. To do that, we will help her obtain employment authorization so she can support them while she waits for her asylum application to be adjudicated. And that's extra important because, as we know, the backlog of asylum applications is quite substantial, and the whole process can take several years.
So together with Ava, our office filed her and her son's asylum applications online. The availability of online filing for asylum is relatively new, and we are hopeful that it will be a big improvement for our clients. One benefit about the online filing process is that Ava received an immediate receipt notice, which is important for certain public benefits applications in Illinois. It's also important for when it comes time for her to file her work permit. So after 150 days, we will apply for a work permit for her and her son in order for her son to have identification and a social security number. Then we will continue to wait for her interview. Legal Aid Chicago will represent her before U.S. Citizenship and Immigration Services and the Asylum Office in a non-adversarial interview. Once the interview occurs, we will wait to see if she is granted asylum at that stage or if she is referred to immigration court. There is currently a huge backlog for many affirmative asylum applicants, as Maggie mentioned, and it will be likely several years before Ava is scheduled for an appointment and then to receive a decision. Assuming her application is approved, Ava can then file to have her husband enter the United States as a derivative asylee. In the meanwhile, we are seeking to bring her husband potentially to the United States through routes such as humanitarian parole. Our goal is to reunite her whole family in the United States, and to reach that goal, we will apply for their work permits and we will try and bring her husband here.
Hi, everyone. Thank you to our amazing immigration team for that excellent and informative presentation. We'd now like to share with you a number of ways where you can help. We could use your help as a volunteer. We could use your help also joining our ambassadors board. And in addition, our first in a long time in-person luncheon is coming up on June 13th, and we'd love to see you there. There's still time for firms and companies to sponsor this event. Any donation you make will help continue our work for equal justice and ensure clients who need help with their immigration cases receive the expertise of this amazing staff, and hopefully your help as well. So this concludes the planned content portion of today's presentation. We'll now start the Q&A portion. But before we do, a quick reminder, we'd appreciate if you could fill out a brief survey about the presentation. To do that, or if you'd like CLE credit, click on the link in the chat and fill out the form. And please join us for our next Legal Aid Matters session on medical legal partnerships. The panelists will now remain to answer your questions. We see that there are a number in the chat. So thank you for coming today, and I'll turn it over probably to Alix to start answering some of the questions.
Yes, thank you, Lisa. Thank you so much for your participation today and for putting questions into the chat. initially, I'll just start going through some of the questions that have already been asked. So I'll start with the first one from Tracy. Thank you for that question about what we're seeing, sanctions and other kind of political issues, which definitely inform push factors. There was actually litigation in the 1990s that addressed taking political considerations out of asylum adjudications. So that's always something that's available if clients and attorneys think that it would be useful. An important note, I would say, we're not saying that all of these new arrivals or even all of our clients that we're discussing today qualify for asylum. We're really more just trying to give an overview of where they're coming from and what we're seeing of the facts that they've experienced. So thank you for that question. We have about 2 questions, I think, about evidence. I think those are really good questions. Thank you. So asylum applicants can win asylum on testimony alone. If their testimony is credible, it is a possibility. Now, I will say that all of these cases of the new arrivals are all subject to the Real ID Act, which means that applicants must provide corroborating evidence where it is reasonably available. And so, the government understands that sometimes people flee and can't bring anything, or certainly on this dangerous trek that Romina described, sometimes people have documents that are stolen or destroyed by weather. And so applicants in that case would explain to the immigration judge or the asylum officer what happened to their corroborating evidence. And so specifically about Carmen and the father of her children, she doesn't have to prove that he's part of the Tupamaro, but if she doesn't have any evidence, then her testimony will be specific and detailed, and she will explain how she knows that he is part of this group, including she saw him get into the vehicle, or she knows that he spends time with them, or he told her. She'll include information so the immigration judge or the adjudicator can understand that. So there was a question about refugees. Thank you for that question. Maggie touched a little bit on the difference between refugees and asylees, but it's always good to look at the differences there. So refugees are actually processed entirely outside of the United States, which means they essentially apply abroad, and their applications are vetted and processed and then re-vetted. All of the security checks, all of that happen abroad before a refugee is allowed to enter the US. And so when a refugee enters the US, they're actually entering with that lawful refugee status. And so once a refugee enters, they do not need to apply for asylum in the US. So that's one of the big differences. Finally, I see there's more questions. This is so great. Another question I had looked at was about the adjudication discrepancies. Yes, thanks so much for narrowing in on this. Those discrepancies can be pretty shocking, and I would say they're not always explainable. They can be important to examine. Some of it is just the discretion that is built into the system for the adjudicators in terms of credibility assessments, and then asylum itself is a discretionary benefit, and so that can play a part in some of the discrepancies in the decisions. Let's see. Okay, so there's a question related to the discrepancies about, can asylum seekers change venue to maybe get a better case? I would say generally individuals are allowed to move within the US, and then they can petition the courts through a change of venue motion to change the location of their hearing to their new location. Those might not always be granted. There's also sometimes the law will vary. So the individual hearing may be heard in one location, but then the appeal happens in a different location. And so that might also affect adjudicators and the variance. Oh, let's see, we have a question here about interpreters. Thank you. Yes, so the government does need to provide interpreters. What I'll say is, so immigration court does have interpreters available by phone. They have in-person Spanish interpreters, but some of the issues that we were speaking to is that when we have a less common language in the US, it can be very difficult to find interpreters, even through the government accessed services. But you're exactly right. That is a potential due process issue. And again, that just speaks to the need to really get these folks representation, because due process is an issue that would be very difficult for a pro se applicant to bring up, but is something that an attorney really could help with.
I also want to add that there is if you look at asylum applicants from Afghanistan who are OAR to OAW applicants, they are asking applicants to bring their own interpreters, just because the sheer number of cases is really hard on the government interpreters to just do back to back asylum cases.
Yes, thank you, Romina. I saw a question here about housing. Although oh yes, how do asylum seekers support themselves and find housing? So that's a great question, particularly because there is that delay in the work permit. And I would say the delay is even longer than waiting from when you file your asylum application to when you get your work permit. It's also the delay on the front end before you even file for asylum, as you're getting health care and getting settled and finding housing. And so we mentioned 6 months for a work permit, but we need to think it's actually longer because of that time on the front end. So the state of Illinois has been really great in helping to find shelters in the Chicago area, in kind of suburban Cook County. A lot of the clients that we see and the individuals that we see when we do legal orientations are being housed in hotels and are now applying for some rental assistance grants and moving out of the hotels into apartments in the area. There are some benefits in Illinois. We have what's called the VTTC, which is, I think, victims of trafficking. I forget what the other T is, and crimes.
Torture,
thank you. So it's victims of trafficking, torture, and other crimes. And it's mostly for people who plan to apply for asylum or U visa. And there's a fund there that they can apply to with. And that fund was really created to get to exactly what this question is that there is a gap and people need help supporting themselves before they can get to where their work permit will be approved.
There's a question about delays in asylum decisions, specifically in the Chicago court. Did you see that one? Do you have a sense of whether there's a delay in issuing decisions from the Chicago Immigration Court? We have a couple of cases that haven't received decisions from hearings 6 to 8 months ago.
I am not sure about that specifically. Our office does handle some removal cases, although I would say most of our office's removal cases deal with U visas or other forms of relief, and so we often don't go to, excuse me, an individual hearing where we would be getting a decision. That does seem long to me. I know, all across the government agencies, there's a backlog and they are shuffling resources around and trying to deal. And so I don't know if that delay might be related to new arrivals or something else. I'm not really sure.
Okay, we'll take one final question. Did you see any others? I wanted to just add one comment about looking for a venue where you might have the possibility of a better decision. It's very difficult, if not impossible, to do that. The individuals who are coming and arriving at the border recently are being processed, some of whom the border officials have time to begin their process before the immigration judge by filing the case in Texas or the border state, usually Texas. Others are given paperwork and allowed to leave, and later the government will file those papers in the immigration court where they said they were going. So they have very little control over where their case is going to begin. And it's also not easy to just request a venue change to say, I think New York might be a better place or Chicago might be a better place, so I want my case moved there. Judges will not change venue easily for that type of a reason, if at all. Generally, venue is changed when perhaps you are moving, but you have an attorney on the other end. So there's good reason for you to move your venue, but it's not a highly flexible request to make, nor can you choose it for a reason such as the one that was suggested in the question. So it's pretty controlled. I just wanted to sort of make that point.
And then before we conclude, I wanted to just make sure we didn't have a second CLE code that we needed to put on the screen. I think maybe we're just relying on the one in the middle. Okay.
Great. Thank you, everyone. Thank you to the
Thank you.
presenters. Thank you for attending.
Thank you all. Be well.
Thank you.